During your case, there are other considerations that you will want to keep in mind. Keep in mind that a court case is a long process. Throughout that process, you may have many different court dates for different purposes, including case management conferences, motions and hearings, discovery, settlement conferences, trials, and other court dates throughout your case. We will cover more details on these other aspects of your case in our second workshop. You will see on the slide civil case process mapped out for you. We've talked about the case beginning with a complaint or petition being filed and then being served to the defendant. The next steps in the case will include the defendant having the opportunity to answer, possibly a case management conference, discovery, trial, settlement, and ultimately a resolution to your case. A few other considerations that you will want to keep in mind before beginning a court case are the fact that there are defendants who are what the court calls judgment-proof. What this means is there are certain people or entities who you may file a case against, and you may win in court and get a judgment in your favor. However, if that defendant who you won a judgment against is broke or can hide their assets, then collecting your judgment, actually getting the money that you were awarded, may be difficult or even impossible. That's something to think about before you decide to file a case. If you end up in a situation where you have a judgment against a judgment-proof defendant, then there are a couple of avenues you can take to try to collect your judgment from the defendant. One example is to hire a collection agency. Another is to proceed through another court process called the writ process. There are a few potential outcomes that you'll want to consider before you begin your case. Keep in mind that any time a case is begun, there will be a winner and a loser of the case if the case goes through the court process to a trial. In a trial, there is no certainty as to who will win. As well, remember that there is the possibility of a default scenario. A default scenario occurs when a plaintiff begins a case by filing paperwork with the court, has the defendant properly served with the paperwork, and the defendant fails to respond to that paperwork within the set time limit for your case. If that happens, the plaintiff can then proceed by a default, which means they will be able to proceed through court without the defendant participating in the case, and typically the plaintiff will get a judgment for whatever they had requested in their complaint. As well, there are possible financial losses anytime you begin a court case. Not only will you be paying court costs, you may also be paying attorney's fees for hiring your own attorney. Something that people are not aware of is you may also be ordered to pay for the other party's costs and attorney's fees in your case. So you may be shouldering those costs for not only you, but the person that you are suing. There are a few other considerations that you'll want to keep in mind as you begin a court case. A common question is, do I need a lawyer? There are many good reasons to have a lawyer. Lawyers are very experienced, they know the law, and they know what judges are looking for. Something you may want to consider to help you decide whether you want to hire an attorney or not is the complexity of your case. If you feel that you have a complex case and you really want to go through the court process to a trial, then an attorney may be able to help you do that successfully. However, if you feel that you are more focused on achieving a solution to your situation and you're comfortable talking through that with the other party in your case, then you may be able to handle the case yourself without an attorney. Speaking of trying to resolve your case yourself, there are many different ways that your case can be resolved. Alternative Dispute Resolution Options, or ADR for short, is the common name for the many different ways of settling your case without suing in court. ADR includes many options: mediation, arbitration, neutral evaluation, special masters, referees, binding arbitration, and settlement conferences are some of the common forms of ADR. The most commonly used types of ADR are settlement conferences, which happen in court, typically with a judge, as well as mediation, which I'll talk about in a moment, and arbitration. Before you begin your case, you may be asking yourself, can I settle this case without filing in court? Yes, you absolutely can. You'll want to utilize the services available to you in your county or location, or even at your court. But be aware, while you may be participating in alternative dispute resolution options outside of court, your statute of limitations time limit may still be running, and you want to avoid letting that time limit run out before you have filed your case in court. You may be wondering what types of ADR options are available to you. Many agencies and local counties have mediation programs available. Mediation is when a neutral mediator facilitates communication or discussion between you and the other party in your case to help you reach an agreement that you are both happy with. Arbitration is a different type of ADR. Arbitration is when there is a neutral third person, the arbitrator, who will listen to each party and then make a decision in your case, similar to a judge hearing your case and making an award. Finally, there is settlement. At any time, you can talk directly to the other party to come up with an agreement that you are both happy with and satisfies the problem you're facing. There are many advantages to using ADR options. ADR can save you many resources, including time away from work to go to court dates, or time spent working on your case, as well as money, because your case will involve court fees and possibly attorney's fees. As well, it will save you the energy of working on a case and worrying about the outcome of your case. When you use ADR, you are more involved in your case and in control of your case. You can control the pace at which you work on the case, and you can control the outcome of your case. As well, using ADR can help you preserve your relationship with the other party in the case, where in ADR you are working together to come to a solution, instead of working against each other to win in court. Another benefit of using ADR is that cases that go through ADR can be kept private, whereas cases in court are going to be public record. You do not lose the opportunity to file your case in court just by trying ADR. The only way that could happen is if you allowed your statute of limitations time limit to run out before you filed something in court. If you decide to use mediation as an option to try to settle your case, I want to go over a little bit about what you can expect in a mediation. Mediation can take place face-to-face with you and the other party in the same room, or you may be in two different rooms with a mediator going back and forth between the two of you. In any case, the mediation is going to be conducted by a trained, neutral third party, the mediator. Keep in mind that mediation can happen at any point in your case process. either before you have filed or after you have filed in court. Remember that a mediator has no decision-making authority, and they're not going to decide what is right or wrong in your case. They will not take sides or push for any one solution. Rather, they will maintain a completely neutral role. Mediation will help you focus on the future and what will resolve the conflict. Mediation does not replace the need for legal advice or counseling, but it is an excellent way to resolve your case without going through the lengthy court process. You can also utilize mediation if you have a case in small claims court. Your mediation may take place before your hearing or before filing. Once you have agreed to participate in mediation, your coordinator will contact you to explain the mediation process and discuss your issues. They will also give you the date, time, and location of your session. Remember that your session may take up to 2 hours, and a second session may be scheduled. Your mediation can also take place on the day of your hearing. The coordinator will ask you to meet with a mediator before your hearing begins to try to resolve your case before presenting it to the judge. Thank you for watching So You're Thinking of Filing a Lawsuit. If you have more questions, consult with an attorney or consider viewing our second workshop video, I Have a Case in Court, Now What?